for the High Court of Orissa and district and subordinate courts in the state of Odisha, vulnerable witness deposition centers and virtual courtrooms in district court establishments, and the Odisha Judicial Workflow Automation System for paperless office in the High Court of Orissa, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India, and my Lord Honorable Shri Justice R.C. Chavan, former Judge, Bombay High Court, and Vice Chairperson, E-Committee, Supreme Court of India, to this sacred land of divine architecture, Jagannath Dham, Odisha. With immense pleasure, I am delighted to extend our heartfelt gratitude to Her Ladyship, Honorable Ms. Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir and Chairperson, Vulnerable Witness Deposition Centers Committee, who has kindly consented to join us in virtual mode in spite of her busy schedule, and I welcome Her Ladyship to this inaugural ceremony. We humbly welcome Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, and all the Honorable Judges of High Court of Orissa, both present physically and joined us in virtual mode, and we thank them for their gracious presence in today's ceremony. We also welcome the respected Advocate General and Additional Solicitor General for the State of Odisha, the esteemed President, Vice President, and Secretary of High Court Bar Association, the esteemed members of the Registry, High Court of Orissa, the esteemed district judges and the learned judicial officers of the state of Odisha, members of the print and electronic media, and everyone else who've joined here today. May I now request my Lord Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India, to kindly adorn the dais, and I also request the esteemed Registrar General, High Court of Orissa, Shri Chittaranjan Das, to kindly escort his lordship to the dais. Request the esteemed members of the Registry, High Court of Orissa, to kindly conduct their lordships to the dais. Thank you. We seek the permission of the Honorable Chair to kindly declare this event as open. Thank you, my Lord. As a mark of our heartfelt gratitude, I now request the civil judges on probation to kindly present flower bouquets to our honored dignitaries on the dais. I request Ms. Samvedna Sandeep to kindly present the flower bouquet to my Lord Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India. I request Ms. Sarmishta Padhi to kindly present the flower bouquet to Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa. I request Ms. Krishna Subudhi to kindly present the flower bouquet to my Lord Honorable Shri Justice R.C. Chavan, former Judge, Bombay High Court, and Vice Chairperson, E-Committee, Supreme Court of India. I request Ms. Sushri Sai Priya Tripathi to kindly present the flower bouquet to my Lord Honorable Shri Justice Biswajit Mahanti, Judge, High Court of Orissa, and Chairperson, Orissa High Court's IT and Artificial Intelligence Committee. I request Ms. Pallavi Das to kindly present the flower bouquet to my Lord Honorable Shri Justice Vibhu Prasad Rautray, Judge, High Court of Orissa, Member, High Court of Orissa's Vulnerable Witness Deposition Centers Committee, and Member, IT and Artificial Intelligence Committee. Thank you. English philosopher Jeremy Bentham is often quoted in all legal circles. Today, I'd like to quote him as well when he stated, "Witnesses are the eyes and ears of justice." Today's program bears witness to the commitment of the judiciary to create a safe and conducive environment for witnesses while ensuring quicker access to justice for all. Beginning with the program, I humbly request my Lord Honorable Shri Justice Biswajit Mahanti, Judge, High Court of Orissa, and Chairperson, Orissa High Court's IT and Artificial Intelligence Committee, to kindly present the welcome address in this august gathering. Please.
Good morning, everybody. Honorable Dr. Justice D.V. Chandrachud, Judge, Supreme Court of India, and Chairperson of the E-Committee. Honorable Dr. Justice S. Muralidhar, Chief Justice of our High Court. My esteemed sister and brother judges of Orissa High Court. Honorable Madam Justice Gitta Mittal, former Chief Justice of the High Court of Jammu Kashmir, who is present in the virtual mode. Honorable Mr. Justice R.C. Chauhan, former Judge, Bombay High Court, and Vice Chairperson of the E-Committee, Supreme Court of India, learned district judges and judicial officers who have joined us in this event. The learned Advocate General of Odisha, the President and other members of Odisha High Court Bar Association, as well as the Bar Association from different districts who are watching this event in virtual mode, officers of the registry, and ladies and gentlemen. I am honored to be a part of this momentous occasion when we are about to take yet another significant step towards ICT enablement in the justice delivery system. What makes the event so historic is that Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson of the E-Committee, is with us today to inaugurate the latest e-filing version 3.0 for advocates and litigants of the state. Besides inaugurating multiple number of vulnerable witness deposition centers, virtual courtrooms in district establishments, and Odisha Judicial workflow automation system in the High Court of Odisha. Each of these facilities, which are going to be inaugurated today, mark an important step towards efficiency, transparency, and access to justice. I am happy to inform the august audience that with the leadership of Honorable the Chief Justice and overall guidance of E-Committee and the NIC team at Pune, we have been making all-round efforts to bring advocates closer to the regime of e-filing. In fact, Honorable the Chief Justice has traveled to every district of the state in the past year and early this year to inaugurate e-filing stations to provide assistance to advocates in e-filing and hands-on training on e-filing and other e-services to advocates of those districts. We have repeatedly engaged with the Office of the Learned Advocate General, and he was supportive enough to readily agree to make all state government e-filing through e-filing portal. The same gratitude we owe to the Assistant Solicitor General of India for Odisha, who too extended his support by e-filing all central government related matters. The experience has been one of learning, and I am confident that the new version of e-filing, which is going to be launched today, will make the process of e-filing more convenient and conducive. The initiative of opening vulnerable witness deposition centers with virtual courtrooms was undertaken by our High Court at the behest of our Chief Justice a few months back in the districts of Bhadrak and Malkangiri, with the objective of providing conducive ambience to vulnerable witnesses for deposing their evidence before courts. In the light of the directions issued by the Supreme Court of India in Smruti Tukaram Badade versus State of Maharashtra and another, we have initiated the process of opening vulnerable witness deposition centers with virtual courtrooms in all district court establishments. It is indeed a matter of honor for us that Honorable Dr. Justice Chandrachud, who is the author of that judgment in Smruti Tukaram Badade, is himself with us to inaugurate multiple number of such vulnerable witness deposition centers in various district court establishments across the state. OJWAS, that is Odisha Judicial Workflow Automation System, which we seek to introduce in the High Court and then gradually in the district courts, has been made possible with the unstinted support of the state government. In fact, OJWAS is a version of OSWAS, that is Odisha State Workflow Automation System used in the offices of state government, customized specifically for automating the administrative work of the High Court and district courts. We aim at revamping the way office work is done in the state judiciary by bringing in the best of the ICT through OJWAS. Today, I feel privileged to welcome Honorable Dr. Justice D.Y. Chandrachud, who has been gracious enough to be in our midst to inaugurate these ICT-enabled services. Your Lordship's presence has truly made this day memorable for all of us in the High Court of Orissa. I also feel honored to welcome Dr. Justice Muralidhar, our Chief Justice, who continues to lead us in our endeavors to make the justice delivery system better and better with every day that goes by ever since he assumed the office of the Chief Justice. I welcome my esteemed sister and brother judges of our High Court to the event, who have always extended their solidarity in every endeavor undertaken for the greater good. I heartily welcome Madam Justice Geeta Mittal, former Chief Justice of the High Court of Jammu Kashmir, who has graced this event. It is indeed an honor to have her with us as we embark upon the work of establishing BWD centers across the state. I am delighted to welcome Mr. Justice R.C. Chauhan, former judge of Bombay High Court and Vice Chairperson of the E-Committee Supreme Court of India, who was gracious enough to accept our invitation to be with us today, traveling all the way to Odisha. I welcome learned district judges and judicial officers who are participating in this event, the learned Advocate General of Odisha, President and other learned members of Odisha High Court Bar Association. As always, it is very reassuring to see the representatives of the bar standing together with us as we step into a regime of positive change. I am glad to welcome the esteemed members of the E-Committee constituted by the judicial officers and technical persons who are driving the technological initiatives of the E-Committee for the benefit of stakeholders. To see them joining us all the way from Delhi through video conferencing is indeed a matter of joy. I also welcome the team of officials from NIC, Pune and Odisha, who have been the backbone of every technological endeavor that judiciary has been able to make, especially for coming up with the promising version 3.0 of e-filing under the aegis of the E-Committee Supreme Court of India. I welcome the members of media and distinguished guests to this event. I wish you all a wonderful time during the event. Thanking you all.
Thank you, my lord, for the warm welcome extended to our distinguished guests. Our next speaker, Honorable Shri Justice R.C. Chauhan, was elevated to the bench of the Bombay High Court in the year 2005. As Vice Chairperson of the National E-Committee, Supreme Court of India, I would like to quote his lordship when he had stated that hybrid courtrooms are not only the future, they are also the existing necessity of our judicial system. So with immense gratitude, may I now humbly request my Lord Honorable Shri Justice R.C. Chauhan, former Judge, Bombay High Court, and Vice Chairperson, E-Committee, Supreme Court of India, to kindly address the gathering.
Honorable Dr. Justice Chandrachud, whose vision and energy is driving the e-courts project for achieving accessibility, speed, and transparency in the system. Honorable Dr. Justice Muralidhar, Chief Justice of Odisha, who pioneered first paperless court in the country when he was judge of Delhi High Court. And I had the advantage of actually seeing him operating a paperless court in Delhi. Honorable Ms. Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir, again as judge of Delhi High Court, rendered a judgment in which she prescribed a novel form for replies and written statements. So she suggested that the replies and written statements could come in the next column. First column would be petition or plaint, and para-wise replies would come in the next column, making it easy for even the person who drafts replies as well as the judges to see it. And now she's heading Vulnerable Witnesses Protection Committee. That's a very great job. Honorable Shri Justice Biswajit Mohanty, Chairperson of the Computer Committee of this court. Honorable Judges of this court, Advocate General Shri Parija, Advocate Mishra, the President of High Court Bar, Additional Solicitor General, my colleagues in the E-Committee, gathered members of this bar, judicial officers, officers of the registry, and my dear friends. My heartfelt thanks to the Chief Justice and the High Court of Odisha for giving me this opportunity of sharing a few thoughts on this momentous event of launching e-filing 3.0 in Odisha, as well as the Vulnerable Witness Deposition Centers and virtual courtrooms. The Registry of the High Court and the CPC, Shri Anupam Patra, deserve compliments for speedy implementation of the system. May I mention that when the registries and project coordinators all over the country were struggling to find connectivity, this High Court ensured that BSNL provided connectivity to all courts. And this has cut a big bottleneck, removed a big bottleneck in implementation of the project. The Union Law Minister recently replied in the Parliament about advantages of e-filing 3.0 developed by the NIC team at Pune under the leadership of Shri Ashish Shiradhonkar. I'm delighted to know that the Honorable Chairperson's letter to the Chief Justices to ensure that all government filings at least come in virtual mode has been implemented in Odisha. And the Advocate General and the ASG deserve compliments and thanks for this, as well as the government of Odisha for doing this. Once this is used, e-filing is used by all stakeholders in all courts, it would reduce the influx of paper in courts at least by half. The other half could be eliminated, or rather should be eliminated, under the dynamic leadership of Dr. Justice Muralidhar and the judges of Odisha High Court, by ensuring that all reports from the police and prosecuting agencies of the state are received by all criminal courts through ICJS only, interoperable criminal justice system. If this is done, bulk of paper comes to the magistrate's court, and if that is eliminated, our courts will go paperless. The High Court may also consider directing that in every district, using the available hardware, the staff of at least one criminal court may start digitizing records of pending cases. We are focusing on disposed of cases, but if we focus on pending cases, then it will be easy to convert all courts, magisterial courts, into a paperless mode. So taking up cases listed for a week or fortnight later and uploading the files, just as e-filing is done by advocates or parties, we could build up a database, and slowly in course of 3 or 4 months, we would have no paper in the racks of the courts. Courts will be clean. Papers to be given to the accused, no issue. They have to be given. They don't remain in the court. The advantages of this are immense. A special module to enable the court staff to upload all these papers which are to be digitized by the court staff has already been developed, and it could be deployed the moment you ask for it. Now, this will ensure that there is speed and transparency in the system. This will ensure that we have better optimal utilization of resources of the court, because we could have intelligent scheduling. Once the machine starts reading the documents, reading the papers, it will be able to find out which witness is going to appear several times in the same court, etc. And intelligent scheduling will reduce pressure, not only on the courts, but also on the witnesses and the government machinery. Police officers or particularly doctors coming to the court again and again is a very sad spectacle when our public health system is short of doctors. So let us try to do it. And I suppose with Dr. Justice Murgidhar at the helm of affairs. And today is my New Year day, incidentally. And on 14th, it will be New Year day for Odisha. It will be New Year for Odisha. I suppose New Year will mark some great change, which will be a path breaker or laying down a path for the entire country. Unfortunately, we fail to recognize that our entire legal system is losing its credibility. On the one hand, all crooks and criminals shout from the doorsteps, from the rooftops, that they have full confidence in the judicial system. Whenever some arrest is made, the political leader who is charged of that crime says, I have full confidence, full faith in the judicial system. And on the other end, we have our own people who headed the judiciary saying that I don't have faith in the system. So therefore, this truth we must accept, that credibility of judiciary, credibility of the legal system, credibility of advocacy has eroded. And we have to bring back that glory, redeem the glory of days when great people, leaders of the country actually came from the bar. So let us try to do it. And this can be done by implementation of directions of Dr. Justice Chandrachud in Swapnil Tripaঠি's case about live streaming. Live streaming has begun at some places, no doubt. Sporadically, it is being done. It was an eye-opener. It was a good experiment for us to know how it works. But then we realized that, at least I realized, that we are really not prepared for live streaming because we have not prepared ourselves for live streaming. How we appear on the screen, we have never tried to find out. Therefore, again, my earnest request to Dr. Justice Murgidhar and the committee here, and fortunately, we are in the auditorium of the Judicial Academy, to start video recording of court proceedings in magisterial courts first. This is not for the purpose of streaming. We will prepare ourselves for streaming afterwards. But first, before going live, let us record those proceedings, let them be reviewed by a peer committee, local committee of judges to find out what is wrong, what is right, what should have been exemplary conduct, what should have been avoided, etc. In the Judicial Academy also, these video recordings could come to the Judicial Academy, and Judicial Academy could find out how the conduct of judges before the camera could be improved. Since the leader of the bar, Advocate Chandrachud, and the president of the bar is also here, they may also consider whether the bar would like to have a look at the recordings of how bar members appear before the camera. Because ultimately, it is a question of image of the entire system, not just judges. The image of advocates is as much important for us. How we appear before the camera has to be first looked at. Maybe we may have some experts guiding us, counseling us about appearance on camera, appearance on the screen. And then we may be ready to go live. So if we start this now, maybe in say 3 or 6 months, we may be able to say that our judicial officers, our judges, our advocates have no fear of camera, have no fear of how public would view those recordings. So let us start this internally for us, for our purposes, not for public consumption. And media would of course excuse us because they would understand that this is in the interest of the image of judiciary, image of the system. I'm sure that the Odisha High Court, which has been taking lead in all other matters, like developing centers for vulnerable witnesses, will take a lead in this regard also. I thank all of you, and I thank the Chief Justice and judges of Odisha High Court for giving this opportunity of sharing a few thoughts with you. I thank my chairperson, Dr. Justice Chandrachud, for giving me an opportunity of trying to race or trying to match his speed of work, though I can't. But I do try. Thank you, sir.
Thank you, my lord, for enlightening us on the importance of a paperless justice system, virtual courtrooms, and emphasizing the need to re-establish and uphold the credibility of the judiciary. Our next speaker of this event is Honorable Miss Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir, and she's the first woman judge to serve in that capacity. The decision rendered by Her Ladyship in the case of Suhail Rashid Bhatt versus State of Jammu and Kashmir, in which Her Ladyship decriminalized beggary, is a testament to Her Ladyship's sensitivity to the plight of the vulnerable sections of the society. Her Ladyship's commitment to making justice accessible to all and courts more human was again highlighted in the case of Virendra Singh versus State, where Her Ladyship emphasized on the need for creating a comfortable environment for child witnesses and victims. So, may I now humbly request Her Ladyship, Honorable Miss Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir and Chairperson, Vulnerable Witness Deposition Centers Committee, to kindly address the gathering. Your Ladyship, please.
Please let me join. Yeah, thank you. Thank you, Anupam. Can you hear me? I cannot tell.
We can hear you.
Okay. I'm sorry for this little technical lapse. I also apologize for not being present physically with all of you in Odisha. I had so looked forward to coming to not only attend the program, but meeting all my brother and sister judges, and most especially to see the wonderful facilities which you have been able to create in Odisha. Unfortunately, I suffered a bereavement. I'm very grateful to the IT team, Anupam Patra, for enabling me to join you from Bangalore. Actually, I'm not even in Delhi. Justice Chandrachud, Judge Supreme Court of India, my very dear brother, Chief Justice Muralidhar, Justice Chavan, sister and brother judges of the High Court of Orissa, sister and brothers of the judiciary of Odisha at all levels, director and faculty of the Judicial Academy, law officers of Odisha, office bearers and members of the bar in all the bar associations in Odisha, staff of the registry, the IT team, and the wonderful members of the Vulnerable Witness Deposition Committees in Odisha. Greetings from Bangalore on Ugadi to all of you. May the festival usher in an era of prosperity. I believe it is celebrated in Maharashtra as well. So greetings from all these, to people in all these places, and to even to those who do not celebrate the festival. I must congratulate the judiciary of Odisha on this wonderful achievement of taking the initiative of setting up vulnerable witness deposition complexes in every district of the state. I, from 2012, had been taking tremendous pride in the fact that we had been able to achieve this unique distinction in Delhi. For me, it is truly extremely gratifying that we have been able to carry this initiative to Orissa and other parts of the country only because of a judicial intervention of the Supreme Court of India, led by a bench presided over by Justice Chandrachud, and the kind of judicial intervention which we are undertaking, which to my mind has become a movement only because of the order dated 11 January 2022 passed by the Supreme Court. I have no words in which to express my satisfaction at this evolution of this movement. Judicial systems are preoccupied with the innocence of the accused as well as the development of the adversarial system, where public represented by the state is pitted against the accused represented by the defense. This system, therefore, completely fails to include any consideration of the victim or the witness or the needs and interests of these persons in the criminal justice process. This becomes worse where the victim is a witness as well, especially in cases of sexual violence and other heinous crimes. Clearly, it is only a statement of the obvious if I would point out that there has been a historic neglect of the rights of witnesses as well as victims of crime. Judicial pronouncements as well as literature abound on the aspect of secondary traumatization of victims visiting the foreboding court environment, as well as in having to recount their experience in courtroom depositions, where they have to stand shoulder to shoulder with the very perpetrators. Statutes have attempted to provide shields in the nature of camera trials, as well as segregation of the victims by use of screens, etc., in courtrooms. This, however, has been found to be completely insufficient. The Vulnerable Witness Deposition Center is actually, as I said, an instance of judicial intervention and judicial initiative in attempting to balance between witness protection and fair trial, while ensuring access to justice to victim witnesses. Despite separation, it enables the witness to remain visible and audible to the defense and the accused at all points of time. Thereby, there is compliance of the constitutional and statutory mandate that a criminal trial must be in the presence of the accused. At the same time, we have safeguarded the sensibilities and the trauma of a victim and a witness. There are several additional aspects which we shall discuss over the next few years. Establishing infrastructure alone shall not suffice, and we shall flesh out the same by way of trainings to import the necessary sensitization to all stakeholders, which include not only the judges, but also the support persons, the prosecutors, the defense lawyers, legal aid lawyers, as well as, most importantly, the police. We shall endeavor to see if we can include the trainings of doctors and take the program to schools to sensitize 14 to 17-year-olds of the myriad difficulties and the nuances of the law. I found in Delhi that it was absolutely imperative to sensitize doctors as well as 14 to 17-year-old boys, girls, and those of the third gender, as that will result in not only mitigating the agony of victims, but is extremely necessary to have an impact on the social values, the social norms, as well as the range of offenses which we see occurring in society. The most important outcome, however, has already emerged. It is the realization on our part that following universal procedures in all cases does not always result in justice. That we are today inaugurating 15 vulnerable witness deposition complexes is testimony of the important fact that you are undertaking this as thus a project in every district already is a matter of tremendous elation. I hope that traveling together in this journey, we are able to create comfortable and safe spaces where the dignity of vulnerable witnesses is maintained so that they are enabled to confidently testify and assist courts in dispensation of justice to society. And justice is done to the victims as well. Before parting, my request to the E-Committee of Justice Chandrachud is to kindly examine another very, very important project of digital inclusion, which I had experienced extreme exclusion in Jammu and Kashmir over the 2.5 years that I was there. And we had launched a project called Insaf Ki Dastak, knock of justice at the doorstep. It was an initiative of the High Court of Jammu and Kashmir. It enabled digital inclusion to the most marginalized living in in areas which are cut off from the rest of the state and the country for 8 months at a time because there was snowbound and under 8 to 12 feet of snow for 8 months. We enabled filing of cases in common service centers, banks, post offices. Templates of claims and complaints were provided, which any person could fill up in their handwriting and communicate them using faxes, internet, or whatever mode to a court, where we had created special counters for the same. This is a very, very important aspect. So as you launch e-filing on the 3.0 platform in the state of Odisha, which is an initiative of Justice Muralidhar in the Delhi High Court. He pioneered the same in Delhi, and it is so heartening to see that he has, expanded. He already has a tremendous vision, but this initiative to Orissa as well. My best wishes and my congratulations to the entire court, led by Justice Chandrachud, the entire team of the EE systems, as well as the vulnerable deposition complexes, and an expression of hope that this will truly be a very, very successful initiative. Thank you very much for enabling me to join and participate in this very important function, which marks a very important milestone which has been achieved today by the High Court of Odisha. Namaskar.
Thank you, Your Ladyship, for sharing your valuable insight on the plight of vulnerable witnesses and the steps the judiciary needs to take to sensitize themselves to the situation of the vulnerable section of the society. Moving on, it is my utmost privilege to request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly address the gathering.
Thank you, Sugandhya. Pranam, very warm good morning to everyone. Warm greetings on Yugadi. This is a special honor for all of us to have Dr. Justice D.Y. Chandrachud in our midst, Judge Supreme Court of India and Chairperson of the E-Committee, whose guiding light is what is keeping us all moving forward in the right direction, where we're looking at transformation of the justice delivery system through digitization, through technology, through better access to justice. That is ultimately the goal that we are seeking to achieve. I'm very happy to have in our midst Justice Geeta Mittal, my dear sister judge, who is the former judge of the Delhi High Court, a former Chief Justice of Jammu and Kashmir, presently heading the committee for vulnerable witness deposition centers. Justice R.C. Chavan, former judge of the Bombay High Court, who's presently the Vice Chairperson of the E-Committee, Supreme Court of India. So we're very happy that you could spare time to come and join us here today. He too has been guiding us in various ways. In fact, his entire team, the entire team of the E-Committee is present here with us online. Arulmozhi Chelvi is there. There is Shirodankar, Ashish Shirodankar, there's Anil Kulekar, there's Ramesh Babu. All of them have been working tirelessly in making sure that we get our 3.0 e-filing. We're very grateful that their participation is there here today. My dear colleagues, of course, Justice Mohanty, who's on the stage, and Justice Rautre. Justice Mohanty has been heading the IT committee. He's taken the baton over from Justice Pujari, who's also with us here, who was the IT committee when I joined the High Court here as Chief Justice. It's been a march forward as far as Orissa is concerned, thanks to the active involvement of the entire IT committee, headed first by Justice Pujari and now by Justice Mohanty. We have online Justice S.K. Sahu, who's heading the Vulnerable Witness Deposition Center Committee. And this project draws its vision from what the E-Committee has been saying, of course, from the judgment rendered by Justice Chandrachud, and also from what we've been doing in the Delhi courts when I was there as a judge. And Justice Geeta Mittal played a very active role in making sure that those vulnerable witness courtrooms get inaugurated in every district complex in Delhi. So there has been a lot of learning which we've been able to bring to Orissa. and we're constantly guided by that. I think we also have the participation of Vibha Datta Makija, the senior advocate of the Supreme Court of India, who is the amicus curiae, assisting the court. And we'll be also reaching out to her for suggestions on how to improve our systems here. We need information, help from all sources, and we're ready to take all of that to move forward. My dear colleagues who are present here, they've been fully supportive of every endeavor of mine, of every endeavor of the High Court. The dear district judges who've been working tirelessly, at least in the districts today where we're inaugurating the vulnerable witness deposition centers, they've literally been working day and night to make sure that the courtroom is fully equipped, not only infrastructurally, but also technologically equipped. Our connectivity is good. So every time we have events like this, it's also a testing for us how good our connectivity is. So I think we've done fairly well so far today. The bar has been fully supportive. Today we have with us the Advocate General, the tall leader of the bar, who's been fully supportive of all the endeavors. As Justice Chavan was pointing out, the readiness with which the state government said yes to compulsory e-filing, the readiness with which the Additional Solicitor General of India, Shri Pari, said as far as the central government is concerned, that encouraged us to go forward with this e-filing project. The bar has been very supportive. We have the new office bearers who got recently elected. They are here present. The High Court bar has been very supportive, as has been the district bar. From our side, we've been having hands-on training of lawyers, both in the High Court and in the district courts. We've trained the law clerks, both here and in the district courts. We're training the judicial officers because we realize that once we bring a new ecosystem of digital courts, of e-filing, all the main players in that system will have to be fully equipped. So we are taking that extra effort of our own master trainers, training the bar, our own master trainers, training the law clerks. This is happening not only in the High Court, but it's also happening in the district courts. And it's not a one-off training program. We have continuous scheduling of training programs. As a precursor to this vulnerable witness deposition centers, we already had virtual courtrooms inaugurated in 4 districts. We started with Hon'ble and Nayagarh. That was very encouraging, the result there, where the district judges, 2 very dynamic district judges, both women, one Rupashri Chaudhary and Madam Bhagyalakshmi Ratha, who's now the Registrar Administration, they could schedule hearings, at least for 2 whole months, where witnesses could participate from remote locations. These were police officers, these were doctors in government hospitals, these were scientists in forensic labs, and it has gone smoothly. We learned from that and carried that experiment to 2 more districts, Bhadrak and Malkangiri. And now I'm very happy to say that all these vulnerable witness deposition centers will also double up as virtual courtrooms, which means that courtroom will be fully occupied all the time. Any judge, even a vigilance judge, even a civil judge, anyone could book that courtroom for examining a witness in a remote location. All that is possible today. And this is the future of the Odisha judiciary. This is the vision that we have for the Odisha judiciary. Justice Chavan should know that we've started the live streaming of the Chief Justice's Court in Orissa High Court with good results. Some more judges have evinced interest of going live streaming. We will carry the paperless mission that you've pointed out to the district courts as well. We have a plan in mind for that. The third initiative today, apart from the e-filing 3.0 and the vulnerable witness deposition centers, is the OJWAS. We learned again from the experience of the Orissa Secretariat. The entire Orissa Secretariat is paperless. And we sent our officers there to get an orientation, to get some hands-on training. And we've got the help of the team that devised the OJWAS system to come and tailor, custom make a software system for us, for the judiciary. We're going to start with the non-judicial branches, where we'll have completely paperless branches, and we'll slowly move on to the judicial branches. The idea is this will happen simultaneous with paperlessness in the Orissa High Court. Already after the inauguration of the paperless court of the Chief Justice's Court, which Justice Chandrachud very kindly did a few months ago, we've had 3 more judges holding paperless courts. 2 more have evinced interest, and slowly the movement is growing for having paperless courts in the Orissa High Court. All of this has been possible because of the complete cooperation of not only the bar, my colleagues, the district judiciary, the staff, the lawyers in the districts, but also the state government, the local administration. Everywhere we've found a good response, good support. But I must say that the guiding spirit is the E-Committee of the Supreme Court of India. We get our energy, we draw ideas from whatever the E-Committee does, and that is how we are able to move forward. I'm looking forward to more such initiatives in the future. We want to take Odisha judiciary forward. We want to make it among the best in the country. Thank you so much for your patient listening. Thank you, Justice Chandrachud, for being here with us. It's indeed a very, very happy Yugadi for all of us. Thank you. Jai Hind.
Thank you, Your Lordship, for sharing the vision of taking the judiciary a step forward towards establishment of a paperless justice system while ensuring the safety of the vulnerable sections. Moving on, it is my honor to humbly request Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India, to formally inaugurate the e-filing 3.0 for the High Court of Orissa and District and Subordinate Courts of the State of Odisha, vulnerable witness deposition centers and virtual courtrooms in district court establishments, and Odisha Judicial Workflow Automation System for paperless office in the High Court of Orissa. Lord, please. Thank you, my lord. We now have a brief presentation on the e-filing 3.0 system, vulnerable deposition centers and virtual courtrooms, and the Odisha Judicial Workflow Automation System.
E-filing version 3.0 developed by E-Committee, Honorable Supreme Court of India, launched by the High Court of Orissa. The e-filing 3.0 is a complete end-to-end solution developed for online filing of cases before the High Court and District Courts of the state. Let's see some of the prominent features of e-filing 3.0. Uploading and e-signing of the pleadings. The facility enables client to e-sign the document uploaded by the advocate from the comfort of home or client's office. E-payments provides facility for online payment of court fee, integrated with respective state treasury payment gateway. Online submission of wakalat by clients helps to authenticate and handshake advocates with the clients for exchanging information electronically. Facility for online video recording of oath. Client can record oath online without visiting the court. Entire filing can be done in asynchronous mode without advocate and client meeting each other when client, advocate, and court are geographically situated at different locations. My partners. Facility for advocates. Add colleagues, juniors as partners in e-filing 3.0 portal. Once added, cases can be assigned to them. The feature helps each of the partner advocates to work on the uploaded documents in the same case collectively and collaboratively. Portfolio management and case planner for new as well as existing cases. Facilities to such cases from the portfolio. Add events to the case calendar. Dashboard with status of all the completed and pending activities related to cases along with monthly calendar are available at a glance. Advocate registration integrated with Bar Council data for verification of advocates. Only verified advocates are allowed to file the cases online. E-filing benefits save time, paper, money, and travel of advocates and clients. Reduce footfalls in the court. Minimize meetings between clients and advocates.
Thank you. Moving on, we are indeed honored to have with us Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, as the chief guest of today's event. His lordship stood out as a staunch upholder of an individual's rights to privacy, dignity, and autonomy in the famous case of K.S. Puttaswamy versus Union of India. Recently, as the author of the case of Spruti Tukaram Badade versus State of Maharashtra, his lordship emphasized on the need for creating safe, sensitive, and conducive environment for recording the evidence of vulnerable witnesses. Now, it is my utmost privilege and honor to request my Lord Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India, to kindly deliver the inaugural address. My Lord, please.
The Honorable Chief Justice of the Orissa High Court, Dr. Justice Muralidhar, brother and sister judges of the High Court and of the District Judiciary, the Learned Advocate General, Shri Ashok Kumar Parija, my distinguished former colleague of the Bombay High Court and now, of course, a colleague in the committee, the Vice Chairperson, Justice R.C. Savan, Justice Geeta Mittal, the team of the E-Committee, which is online for this program, Team NIC, which is really the backbone of the E-Committee, the distinguished officers of the state government who are present here, and all the invitees. At the outset, I must wish you a happy Gudi Padwa, a happy Yugadi. It also happens to be my mother's birthday, and when she was with us, we always celebrated Gudi Padwa with something special which she cooked for us. So it's a special day for me and for all of us today to be assembled here for the unveiling of these unique initiatives. We always say that, well, institutions are above human beings. No individual is higher than the institution. And as judges, we know we are pilgrims in this path. We all come here, occupy these spaces, and then hand over the baton to the next generation of colleagues. And we have received the baton from people who have preceded us. But equally, I think the initiatives which have been unveiled today are a clear indicator of what a person at the helm can do to move the system along. The Advocate General said when we were having a cup of tea this morning, when Justice Muralidhar was very complimentary to the support which is being provided by the state government. And the Learned Advocate General said that, well, the state government has always been there, which is such a truism, because these are, in that sense, sovereign entities which continue to exist, and they've existed before and they continue to provide the existence within the framework of the nation. But he said that, well, this is what the initiative of the Chief Justice can do to move the system. And I think this is really a clear indicator about how a hands-on approach by the Chief Justice can spearhead the adoption of new initiatives, particularly in the field of technology. So my compliments to Justice Muralidhar and to all his colleagues who have really worked together, including the staff of the High Court and the District Court, the judges who are manning the e-courts. I had the pleasure and the honor of inaugurating the 2 paperless courts initially, and I particularly would like to compliment both the judges. I wouldn't say women judges, because they are judges first and foremost. They also happen to be women, but they are most importantly vital stakeholders, and they are part of our system, and they are leading from the front by the work which they are doing. So this really represents, I believe, a bipartisan effort. Bipartisan in the sense it's a combination of an effort by the state government on the one hand and by the state judiciary on the other hand. And why is this coming together of the initiatives of the state and the judiciary so significant? Because our mission is common. In the work which we do as judges in our courts, we stand aloof from all trends, winds, and influences around us. But on the administrative work which we do, we join hands together because we are ultimately in service of citizens. And that's why I call it a bipartisan, a unified effort on the part of the state and the judiciary to ensure that justice delivery takes place for common citizens. both these initiatives, as well as really the OJWAS initiative, the first two in particular, e-filing and the unveiling of the vulnerable witness deposition centers, they combine technology with the human face of justice. Technology in that sense is neither impersonal, nor is technology impervious to human concerns, to the human faces which underlie the work which we do, whether in the administration of justice or in the administration of the state. The beauty of technology, the importance of technology, the strength of technology is that technology is increasingly becoming simpler. The more complex technology becomes at a back end, ironically, is the very reason why technology becomes so simple to use at the front end of it. My wife was just telling me the other day that she was driving down in the car when our driver got a telephone, and she said he just patted the telephone and that was it. He was in contact with his little child and telling the child that I'm driving and I'll talk to you in another 5 minutes when I reach home. So that is how simple technology has really become. So technology is not something, and this is very important for the more senior generations of judges. The youngsters have all begun with technology, they swim with technology. But for the more senior generations of judges, I think it's important to realize when we change or try to change our mindsets, that technology is as simple as simplicity can be. So our effort now that we are on the anvil of phase 3 of the e-courts project is to reach out to citizens as part of phase 3. Justice Geeta Mittal spoke about the need for digital inclusion. I think that's the core of the mission in the phase 3 of the e-courts project. For technology and for the courts to reach out to citizens, as distinct from courts reaching out or the citizens reaching out to the courts. Many of our courts do have colonial origins, but we have now transformed ourselves beyond our colonial origins. Colonial origins provided a sense of grandeur, a sense of fear, a sense of authority for the courts in the minds of common citizens. We have transformed our work and we continue to transform our work so that our citizens are able to understand that we are a part of their lives, not that they have to continually access us through increasing complexity of procedures and law. The government is our largest litigant in India. When judges normally say that the government is the largest litigant, we use that in a fairly pejorative sense, that everything which comes to the court is, or every dispute necessarily is filed in court because nobody wants to take the responsibility of saying, well, this is too small a dispute or too insignificant a dispute to litigate. That's the pejorative way in which we say that government is the largest litigant. But I also look at it in a more positive light. Government is a largest litigant because it is a single most important dispenser of welfare benefits in our society. That was the role which was envisaged for government when at the birth of the nation. And that role has not been denuded despite the onset of privatization and the march of a market economy. The government still continues to be the largest dispenser of welfare benefits. The government is also the enforcer of law. The government is among the largest employers. So this is where the government has a very deep intervention and interface with common citizens in the realization of its revenues, for instance. Now, the reason why I highlight this is that when the government has taken an initiative, when the state government has taken an initiative to ensure that all matters in the High Court will now be e-filed, and so also the ASG has taken the same initiative as the Advocate General has led for his team. I think this provides a mission and a vision for the future, that the largest litigant, not in a negative sense, but the largest litigant in our system, in a positive sense, as somebody who is concerned with the welfare of our citizens, is taking a conscious, a deliberate effort to ensure that the process of justice delivery becomes simplified, it becomes flexible, and it becomes alive to the needs of citizens. Just yesterday, the Chief Justice of India inaugurated what we call the faster delivery of justice, namely the dispensation of orders or the provision of orders which are delivered, or directions or summons or warrants or whatever you have from the Supreme Court of India, right down to all establishment, including the jails, so that, for instance, bail orders can be executed immediately. I think it's important that we replicate this across the country. The use of the National Judicial Data Grid. The National Judicial Data Grid is a mine today of judgments. The NJDG has a unique collection of judgments which have been delivered across India from time immemorial. We have 25 high courts on the NJDG. Data of 58.88 lakh cases is available on the NJDG, and data of 3,30,91,658 cases is available on the National Judicial Data Grid. The Supreme Court is about to join the National Judicial Data Grid, so that every court will be mapped on the same NJDG for the entire nation. Now, how do we use the NJDG? This data is of no use unless we utilize the data which is available on the NJDG. Now, for instance, what we propose to do is to incorporate the use of the NJDG data by initiatives such as the Justice mobile app. The Justice mobile app, which is provided to judicial officers, helps them to monitor the pendency and disposal at their fingertips. Various reports are provided in graphical and grid form, which are available in the mobile app. There is a facility to tag important cases and mark short notes for such cases as are available. These cases are specially marked when listed, and a judge can identify the cases of important nature on the cause list. Separate versions of the app have been developed for judicial officers and principal district judges. So a judicial officer can monitor pendency, the disposal of their cases, along with several new features, such as a briefcase, to view the disposal of cases during previous postings. The principal district judge can monitor pendency and disposal of the entire district under the jurisdiction, and also for each individual judge. The Justice mobile app is also available for the Chief Justice of India, for the judges of the Supreme Court of India, for the Chief Justices of the High Courts, the guardian judges or the portfolio judges, as we call them, because they can monitor pendency and disposal of all the states, the districts, and establishments in India according to the nature of their jurisdiction. The pendency and disposal and monitoring of individual judges under the jurisdiction has also been provided. So the NJDG, combined with the Justice mobile app, will provide us a unique ability to track the performance of judicial officers, including judges across the spectrum, whether it be in terms of making appointments to the Supreme Court, whether it makes for the promotions of judges within the system from the district judiciary itself. So these are some of the initiatives which we, I think, need to look forward with a sense of vision for the future. I was delighted to note that the Chief Justice's Court has gone live streaming in the state of in Orissa. Chief Justice Muralidhar had shared that with me a while ago, and we learned about this a short while ago again. Live streaming is crucial. Live streaming is crucial because the pandemic gave an impetus to technology. But the pandemic was not the reason. The incorporation of technology in the Indian judiciary dates prior to and will survive the pandemic. I believe that what has happened is, as a result of the use of virtual platforms, the Supreme Court of India has become truly a national court. We were always a national court in the sense that we hear appeals in all cases across the country. We have original jurisdiction which spans across the country. But we have become a national court in a participatory sense, where access to the Supreme Court truly is available to every lawyer across India, which generates a sense of confidence of the litigants. The litigants has the first interface with a lawyer in the state judiciary. So when that lawyer addresses the Supreme Court of India, it promotes a sense of confidence in the ability of that citizen to get justice. Second, I do believe that, and this has been my experience, that more women and young lawyers have been able to access the Supreme Court as a result of the video conferencing platform. What has happened because of the live streaming of cases is that lawyers, particularly young women lawyers, who would otherwise find it very difficult to access court with multifold responsibilities, are increasingly taking recourse to the use of the video conferencing platform to access the Supreme Court. And live streaming, I do believe, sends a very important message of the involvement of the citizens and of the accountability and responsiveness of courts towards citizens. Now, of course, live streaming is going to affect the way we do our work. It's going to be affecting the way that we do our work for the reason that we have to adapt to the new demands which social media has placed on us as judges. Every work, every little thing that we do in the court, every little word that we say in the court is almost reported by the second on social media. I don't think you can stop that anymore. But we have to adapt as judges, and we have to adapt ourselves to the new age, not by closing ourselves to these new trends, whether it be in terms of Twitter or be in terms of any form of social media, but by making our systems more flexible, more adaptive, so that we can then really move towards the future. I was delighted that Justice Geeta Mittal took up the work which the Supreme Court thought of assigning to the learned judge. Justice Geeta Mittal had done remarkable work in the Delhi High Court for the vulnerable witness deposition centers. Depositions by witnesses are crucial for the survival of the rule of law. Various jurisdictions across the world have established witness protection programs, for example, by providing temporary residence in a state, in a safe house, or using modern technology to aid testimonies. In cases where the accused persons belong to powerful cartels, the protection of witnesses is enhanced. The United Nations Office has released the good practices for the protection of witnesses in criminal proceedings involving organized crime, where it identified that the resettlement of witnesses under a new identity in a new and undisclosed place of residence is the only viable option for witness protection. These witness protection programs are formulated with a focus on the threat to the life of witnesses. However, the threat of an overt form of aggression is not the only form of threat that witnesses face. Witnesses who have been subjugated and discriminated against due to their identity or their lived experiences need to overcome multi-access barriers and the resulting trauma to depose before the courts. It is our responsibility as members of the judicial system to tailor the deposition process in an adversarial system to the needs of citizens with inhibitions. There is no legislative enactment governing the field of vulnerable witness protection comprehensively. Therefore, the definition of vulnerable witnesses is often restricted to only cover rape victims or child witnesses. Though there is no denying the fact that rape victims and child witnesses require the creation of a special environment for deposition, it is imperative that we also recognize other forms of vulnerability. A society established on unequal power structures is based on multifold individual and group identities. Vulnerable witnesses, therefore, cannot be defined in strict terms, restricted to specific classes of individuals. Vulnerable witnesses must be defined considering the lived experiences of witnesses, specific to the context such as socioeconomic background, age, disability, gender, and a multitude of other identities and their interaction with the surrounding environment. In following this approach, the Supreme Court expanded the definition of vulnerable witnesses to include age-neutral and gender-neutral victims of sexual assault, witnesses suffering from mental illness, persons with speech, hearing, or any other form of disability, and those who are deemed to have a threat perception. The purpose of setting up these vulnerable witness deposition centers is not only to arrive at a reliable verdict in a criminal trial or to make the process of arriving at a verdict foolproof. The primary aim of setting up vulnerable witness deposition centers is to create a conducive and humanized environment for witnesses, to free them of any mental restrictions or impediments that their lived experiences might have created. Therefore, the creation of vulnerable witness deposition centers should not be viewed as a means to the ends of a criminal trial. Rather, the program is an end in itself, an object, a goal in itself, aimed at providing vulnerable witnesses the confidence to face the society and the system. I'm delighted to be here to be speaking to you this morning on the numerous initiatives which we have adopted in the E-Committee. This is only the beginning of our mission, and I do believe that with the association of very enlightened state judiciaries, the mission will go forth. And I'm here particularly because I do believe that the High Court of Orissa, under the able guidance of and stewardship, leadership of Justice Muralidhar, has really taken that lead in providing technology, not as a means to distance ourselves from our citizens, but as technology so as to reach out to our citizens. One of our key initiatives in the very near future is going to be to merge the e-court services with the common service centers, which was, of course, implemented by Justice Geeta Mittal in the state of Jammu and Kashmir, by the Insaf Ki Dastak project. We are planning to now do this across the country. And the merging of e-court services with common service centers is really an effort. We are fine-tuning some of the nuances which are involved in the process, which I hope we will be able to resolve very shortly. But the merging of e-court services with common service centers is intended to ensure that justice truly becomes decentralized, not in terms of judges going to the villages to do justice, but by making available all the services of the judicial system at the doorstep of every citizen in their own villages. I thank the Chief Justice for inviting me this morning. I may have taken a little more time, but then you'll make a little more allowance for me for two reasons. That it took 2 hours to reach Orissa. I would have been more precise if I was talking on a video conferencing platform, but the program entirely would have been over in 1 day, in 1 hour. But having chosen to spend 1 day very happily in the company of all the brother and sister judges of the Odisha High Court, I thought I can share some of my views in a more comprehensive sense than in a short video recorded speech. Thank you very much for inviting me. And we must also thank the little cat for having entertained us when I was speaking. Thank you.
Thank you, Your Lordship, for your kind words of encouragement and appreciation and sharing your valuable insights into the initiatives taken by the justice delivery system to combine technology into the justice system without losing the human aspect of the same. Moving on, as a token of our respect, humble appreciation, and gratitude, we would like to present mementos to our esteemed guests to honor their presence in this distinguished gathering. May I now request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly present the memento to my Lord Honorable Shri Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India. Thank you, Your Lordships. May I now request my Lord Honorable Shri Justice Biswajit Mahanti to kindly present the memento virtually to Her Ladyship Honorable Ms. Justice Geeta Mittal, the former Chief Justice of High Court of Jammu and Kashmir and Chairperson, Vulnerable Witness Deposition Centers Committee. Thank you, my Lord and Her Ladyship. May I now request my Lord Honorable Shri Justice Bibu Prasad Rautray, Judge, High Court of Orissa, member, High Court of Orissa's Vulnerable Witness Deposition Centers Committee, and member, Odisha High Court's IT and Artificial Intelligence Committee, to kindly present the memento to my Lord Honorable Shri Justice R.C. Chavan, former Judge, Bombay High Court, and Vice Chairperson, E Committee, Supreme Court of India. Thank you, Your Lordships. May I now humbly request my Lord Honorable Shri Justice Bibhu Prasad Rautray, Judge, High Court of Orissa, member, High Court of Orissa's Vulnerable Witness Deposition Centers Committee, and member, Orissa High Court's IT and Artificial Intelligence Committee, to kindly propose the vote of thanks. Lord, please.
Pranam, Namaskar. Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India and Chairperson of the E Committee. Honorable Dr. Justice S. Muralidhar, the Chief Justice, High Court of Odisha, my esteemed sister and brother judges of the Odisha High Court, Ms. Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir and presently Chairman of Vulnerable Witness Committee, who is present through virtual mode, Mr. Justice R.C. Chavan, former Judge of the Bombay High Court, presently Vice Chairperson of the E Committee, Supreme Court of India, and other members of E Committee, Learned District Judges, and other judicial officers who have joined us for today's event, Sri Ashok Parija, Learned Advocate General of Odisha, the office bearers and other members of the High Court Bar Association, the officers of registry, the Commissioner of Cuttack Municipal Corporation, and the DCP of Police Cuttack, ladies and gentlemen. Good morning to everyone. It has been such an honor to stand here to express the vote of thanks and to be part of today's event, which marks a milestone in the march of Orissa High Court on the path of enhancing efficiency and accessibility. Be it the latest advanced version of e-filing or the vulnerable witness deposition centers and the virtual courtrooms, or commencing the process of office automation in the High Court, each of these initiatives launched today is aimed at making the system of administration of justice better and in tandem with best practices. I, on behalf of Orissa High Court, extend our heartfelt gratitude to Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, and Chairperson E Committee, Supreme Court of India, for having been so gracious to be with us in person to inaugurate the e-filing version 3.0, the vulnerable witness deposition centers with virtual courtrooms, and the system of office automation in the High Court of Odisha. It is under your Lordship's vibrant leadership as the Chairperson of Supreme Court's E-Committee that the ICT enablement of judiciary in the country has grown by leaps and bounds, and today, with the inauguration of these e-services by your Lordship, the High Court of Odisha has been able to contribute to this endeavor. Your presence amongst us has indeed been a remarkable gesture of motivation for us and for your inspiring words. I am certain that it will lead us to continue serving the best interest of the institution, particularly by working in tandem with E-Committee. We thank Dr. Justice S. Muralidhar, the Chief Justice of High Court of Orissa, for having been such a tremendous source of guidance in helping us to better serve the administration of justice from the very day he has assumed charge of his office of Orissa High Court. At Orissa High Court. We are immensely grateful to you, sir, for leading us so passionately, especially in the field of ICT adoption in the judicial process for the benefit of all common stakeholders of justice delivery system. We are also grateful to all the judges of Orissa High Court who spared their valuable time to grace this event and make it a success. We extend our gratitude to Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir, presently Chairman of Vulnerable Witness Committee, and Justice R.C. Chavan, former Judge of Bombay High Court, presently Chairperson of the E-Committee, Supreme Court of India, for having spared their valuable time to attend today's inaugural event. Your presence has indeed made this event special. We also express our thanks to all other members of the E-Committee for their valuable contribution. We thank the esteemed district judges, the Director of Judicial Academy, and all other judicial officers who have joined us on today's occasion in physical as well as virtual mode to make this event a success. We also extend our heartfelt gratitude to Sri Ashok Parijal and Advocate General of Odisha, the office bearers of High Court Bar Association present here today for having spared their valuable time to grace this occasion. I extend gratitude to the officers of the High Court Registry for their efforts in making today's event possible. I also extend gratitude to the Commissioner of Cuttack Municipal Corporation and the DCP Cuttack for having joined with us in today's momentous event. Heartfelt thanks to the officers of NIC, the entire team of technical staff, the senior system officer, the system officers, system assistants, system administrators, and all other technical personnel working in High Court as well as in district courts for their hard work and commitment to ensure that as an institution, we continue to accomplish the vision of inclusion and accessibility by making the best possible use of technology. Last but not the least, I convey our gratitude to the members of the print and electronic media who have offered their services to take this message of the court to masses and in whole, and in whose hands shall lie the responsibility of spreading the information of today's citizen-centric e-services for the benefit of the members of public at large. Thank you. Namaskar.
Thank you, my lord. We now request the Honorable Chair to kindly declare this event as closed. Thank you very much.